Rera Real Estate Regulation and Development Act 2016. അതിനെക്കുറിച്ച് കുറച്ച് കാര്യങ്ങൾ നമുക്ക് ചർച്ച ചെയ്യാൻ വേണ്ടിയിട്ടാണ് നമ്മളിവിടെ വന്നിരിക്കുന്നത്. ഈ റെറ ആക്ട് 25 മാർച്ച് 2016 നിയമമായി പാസ്സാക്കപ്പെട്ടു എന്നുണ്ടെങ്കിലും അത് കുറച്ച് സെക്ഷൻസ് 26/4/2016 ബാക്കിയുള്ള കുറച്ച് സെക്ഷൻസ് 19/4/2017 നോട്ടിഫൈ ചെയ്തത്. ഒരു ആക്ട് വരുമ്പോൾ ഒരു സെൻട്രൽ ലെജിസ്ലേഷൻ ആണ് റെറ. ഈ സെൻട്രൽ ലെജിസ്ലേഷൻ കോൺസ്റ്റിറ്റ്യൂഷന്റെ ഏത് ലിസ്റ്റിൽ ഏത് എൻട്രി പ്രകാരമാണ് ഇങ്ങനൊരു നിയമം ഉണ്ടാക്കുന്നത് എന്നുള്ളതാണ് ഫസ്റ്റ് നമുക്ക് നോക്കുന്നത്. അപ്പൊ ഇതിനെക്കുറിച്ച് നമ്മുടെ സുപ്രീം കോടതി തന്നെ ഒരു ജഡ്ജ്മെന്റിൽ പറഞ്ഞു. അതിനെപ്പറ്റി ഒരു വളരെ വിശദമായ ഒരു അനാലിസിസിലൂടെ പറഞ്ഞതെന്താ വെച്ചാൽ, കൺകറന്റ് ലിസ്റ്റിലെ എൻട്രി 6 and 7 പ്രകാരമാണ് ഈ റിലേറ്റബിൾ ടു ദാറ്റ് എൻട്രി, ഈ നിയമം ആ രണ്ട് എൻട്രിയിലും റിലേറ്റ് ചെയ്യേണ്ട ഒരു നിയമമായിട്ടാണ് സുപ്രീം കോടതി പറഞ്ഞിരിക്കുന്നത്. ഫോറം ഫോർ പീപ്പിൾസ് കളക്റ്റീവ് എഫേർട്സ് ആൻഡ് അനദർ വേഴ്സസ് സ്റ്റേറ്റ് ഓഫ് വെസ്റ്റ് ബംഗാൾ ആൻഡ് അനദർ. അതിന്റെ സൈറ്റേഷൻ ഈസ് 2021 8 SCC 599. അതിലാണ് പറഞ്ഞത് റെറ വിൽ കം അണ്ടർ എൻട്രീസ് 6 and 7 ഓഫ് ലിസ്റ്റ് 3. ലിസ്റ്റ് 3 എന്ന് പറയുമ്പോൾ കൺകറന്റ് ലിസ്റ്റ് ആണ്. കൺകറന്റ് ലിസ്റ്റ് പറയുമ്പോൾ എല്ലാവർക്കും അറിയാം, both the central as well as the state government are having powers to bring in a legislation with respect to any matter under that entry. അപ്പോൾ കേരളത്തിലും ഒരു നിയമം അതേപോലെ കൊണ്ടുവന്നിരുന്നു. കേരള റിയൽ എസ്റ്റേറ്റ് റെഗുലേഷൻ ആൻഡ് ഡെവലപ്മെന്റ് ഓർഡിനൻസ് ആക്ട് 2015 വന്നു. ദെൻ ദാറ്റ് വാസ് റീപ്ലേസ്ഡ് ബൈ കേരള റിയൽ എസ്റ്റേറ്റ് റെഗുലേഷൻ ആൻഡ് ഡെവലപ്മെന്റ് ആക്ട് 2015 with effect from 4/5/2015. Ultimately, it was repealed by Kerala Real Estate Regulation and Development Repeal Ordinance on July 15th of 2017. About Kerala also made an attempt. State of Kerala also made an attempt to bring in a like legislation, but in view of the central enactment, it was withdrawn. അപ്പോൾ ഇതാണ് അതിന്റെ പ്രാരംഭമായിട്ട് നമുക്ക് അതേക്കുറിച്ച് മനസ്സിലാക്കുമ്പോൾ എൻട്രി 6 and 7 of List 3 of 7th Schedule of the Constitution is a concurrent subject traceable to. അപ്പോൾ അതിന്റെ what is the importance of that? Concurrent subjectiലാവുമ്പോൾ the state can also come with a new legislation subject to a rider that new law should be reserved for the consideration of the president, and the president should give assent in terms of Article 254(2) of the Constitution. അങ്ങനെയാണെങ്കിൽ മാത്രമാണ് അത് ഓവർറൈഡ് ചെയ്യാനായിട്ട് പറ്റത്തുള്ളൂ. That too only in the state of Kerala, not elsewhere. So, having said that, we will go to each part. Act consists of 92 sections. It is spanning across 10 chapters. ഏറ്റവും ഇമ്പോർട്ടൻ്റ് ആയിട്ടുള്ള നമ്മൾ പ്രാക്ടിക്കൽ പർപ്പസിന് വേണ്ടി പറയുമ്പോൾ ഡെഫിനിഷൻ സെക്ഷൻ ഈസ് വെരി എക്സ്ട്രീംലി ഇമ്പോർട്ടൻറ്റ്. ബട്ട് ഇവിടെ ആകുമ്പോൾ കുറെ ടേംസ് നമുക്ക് പുതിയതാണെന്ന് തോന്നാം, പക്ഷെ many of some terms we will find it in the building rules. ഈ മുനിസിപ്പാലിറ്റി പഞ്ചായത്ത് ബിൽഡിംഗ് റൂൾസിലെ പല ടേംസും നമുക്ക് ഇവിടെ കാണാം, തിരിച്ചും കാണാം. അതിൽ ഫസ്റ്റ് ഈസ് അഡ്വർടൈസ്മെന്റ്. അഡ്വർടൈസ്മെന്റ് മീൻസ് ഇവര് ഈ ബിൽഡേഴ്സ് പലതരം അഡ്വർടൈസ്മെന്റ് കൊടുക്കും. ഇവിടെ എങ്ങനെയുണ്ട്, ഇവിടെ അങ്ങനെയുണ്ട്, ഓൾ എക്സിബിറ്റിംഗ് ഓർ സോളിസിറ്റിംഗ് persons to invest. So that is covered under 2B. Advertisement means any document described or issued as advertisement through any medium and includes any notice, circular or other documents or publicity in any form informing persons about a real estate project or offering for sale of a plot, building or apartment, or inviting persons to purchase in any manner such plot, building or apartment, or to make advances or deposits for such purposes. It applies for the sale of a plot also, development of land into plots also without building. Of course, as per the municipality and panchayat building regulations, development permit we allowed to obtain before that. This is in addition to that. Then another important is agreement for sale. Agreement for sale means an agreement entered into between the promoter and the allottee. Then Allottee is defined. Allottee in relation to a real estate project means the person to whom a plot, apartment or building as the case may be has been allotted, sold, whether as freehold or leasehold, or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer or otherwise, but does not include a person to whom Such plot, apartment or building as the case may be is given on rent. അതൊഴിച്ച് ബാക്കിയെല്ലാം ഈ ഡെഫിനേഷനിൽ വരുന്നു. Then apartment is defined. Apartment, whether called block, chamber, dwelling unit, flat, office, showroom, shop room, godown, premises, suite, tenement, unit, or by any other name, means a separate and self-contained part of any movable property, including one or more rooms or enclosed spaces located on one or more floors or any part thereof in a building or on a plot of land used or intended to be used for any residential or commercial use such as residence, office, shop, showroom or godown, or for carrying on any business, occupation, profession or trade, or for any other type of use ancillary to the purpose specified. So this is the very wide definition of the term apartment. Now, appellate tribunal is defined appropriate government. അതായത് union territory and the state government with reference to a state is state government. Now, architect is defined, which means a person who is registered as an architect under the provisions of Architects Act. Authority is the authority constituted under Section 20. That is authority now constituted as Rera, Kerala Rera. Then there is an appellate tribunal against the orders passed by the first authority. We can go to the appellate tribunal. That is also defined. Then, after defining the term apartment, now building is also defined. Building includes any structure or erection or part of a structure or erection which is intended to be used for residential, commercial, or for the purpose of any business, occupation, profession, or trade, or for any other related purposes. Another very important definition is what is a carpet area. This is very important in the sense that നമ്മൾ ഈ advertisements ഒക്കെ നമ്മൾ കാണുമ്പോൾ ഇത്ര ഏരിയ എന്നൊക്കെ പറഞ്ഞിട്ട് we'll have some indications in the brochure or advertisement where that area and the carpet area now defined under the RERA hitherto are different. Now people are complying with that, have started complying with the definition what is given here. Now you'll have to take note of that. Carpet area means the net usable floor area of an apartment, excluding the area covered by the external walls, areas under services shafts, exclusive balcony or veranda area, and exclusive open terrace area, but includes the area covered by internal partition walls of the apartment. And there is an explanation to this definition. For the purpose of this clause, the expression exclusive balcony or veranda area means the area of the balcony or veranda, as the case may be, which is appurtenant to the net usable floor area of an apartment, meant for the exclusive use of the allottee, and exclusive open terrace area means the area of open terrace which is appurtenant to the net usable floor area of an apartment, meant for the exclusive use of the allottee. So we'll have to read it about 10 or 15 times to fully come understand that definition. Still, it's a very important definition in the sense that a promoter, if he has in his advertisement mentioned something else, and there is the person who comes in and pays, and ultimately when he examines something different what he thought of is given to him, that triggers a cause of action under this act. Now, commencement certificate means commencement certificate or the building permit or the construction permit, by whatever name called, issued by the competent authority to allow or permit the promoter to begin development works on an immovable property as per the sanctioned plan. Before going further, another important aspect is that this enactment in section 88, application of other laws not barred. It says the provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. Section 89, the next section. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. We have to keep this in mind. RERA does not, plus what is stated in sections 88 and 89 have to be read together, and it is on that basis whether one enactment excludes the other can be ascertained. Now, I will give you certain instances where this has been judicially considered. The first is Rera and consumer legislation. Now, Supreme Court has recently, many of my friends here know about it, but I'm just inviting their attention once again. Rera, the remedies under Rera and consumer, both any can be availed. Both of one does not exclude that. That is what Supreme Court said. That is reported in the judgment in 2019 8 SCC 416. Concurrent remedies. You can opt for consumer or for Rera. Regarding the permanent law adalat, one question was raised. What is the jurisdiction, whether the jurisdiction of permanent law adalat is taken away? That is answered in 2023 2 KHC 1. The jurisdiction of the permanent adalat is not taken away because as per the Legal Services Authorities Act, housing is one of the aspects which has been notified under that act also. So therefore, jurisdiction of the Lok Adalat is not taken away. Now, the Surface Act, one of the major issues probably you might also be coming across. A project falling red where surface proceedings are initiated. How does can be reconciled? Now that is also answered by Supreme Court in 2022 2 KHC 112. It said both operates in their respective fields, depending on the situation and keeping open the remedies of the bank and all the financial institutions. Supreme Court said it can, depending on the facts. Now, yet another legislation where a conflict apparently comes is the Insolvency and Bankruptcy Code 2016. Now, Supreme Court said that RARA must give way to court because of the special nature of the insolvency and bankruptcy process. RARA will have to give way to that. One another very important aspect is recently Supreme Court also answered that there is interpreting RARA. Supreme Court said there is an essential difference between a retrospective legislation and retroactive legislation. Retrospective legislation, as you are all aware, it operates retrospectively. It governs the past transaction also. Whereas the thin line between retrospectivity and retroactivity is that retroactivity is something which a legislation will deal with respect to certain past transactions mentioned in the legislation. It is not as if it is entirely retrospective. Certain transactions entered into before the legislation could be covered under this particular statute. That is why Section 3, prior registration of a real estate project with the Real Estate Regulatory Authority. No promoter shall advertise, market, book, sell, or offer for sale or invite persons to purchase in any manner any plot, apartment, or building as the case may be in any real estate project or part of it in any planning area without registering the real estate project with the authority. Now there is a proviso which says projects that are ongoing, applicability of RARA to ongoing projects. Proviso says provided that projects that are ongoing on the date of commencement of this act and for which the completion certificate has not been issued, the promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this act. And there is another proviso also. I'll just read it. Provided further that if the authority thinks necessary in the interest of allottees for projects which are developed beyond the planning area but with the requisite permission of the local authority, it may by order direct the promoter to register of such projects to register with the authority and the provisions of this act and rules shall apply. Another question could be asked: what are those projects which does not come under this legislation? That is also mentioned. That is where the area of the land proposed to be developed does not exceed 500 square meters, or the number of apartments proposed to be developed does not exceed 8 inclusive of all phases. You need not registration under that. And Kerala has framed rules also. For your information, we have Kerala Real Estate Regulation Development Rules 2008. In excess of power is conferred under the Act for the purpose of so many aspects. That is, rule making power is mentioned in Section 84. The registration of the project ongoing is very uh, clearly mentioned in this Section 3. Now, when it come to the grant of registration is in Section 5. A registration once granted can be revoked under Section 7. Registration of real estate agents, that is mentioned in Section 9. No real estate agent shall facilitate the sale or purchase of or act on behalf of any person, facilitate the sale or purchase of any plot, apartment or building as the case may be in a real estate project or part of it. Being the part of the real estate project registered under Section 3, being sold by the promoter in any planning area without obtaining registration under this section. I read the carpet area and building common areas. Common areas have been very clearly defined. Common areas mean the first aspect is the entire land for the real estate project or where the project is developed in phases and registration under this act is sought for a phase. The entire land for that phase. You can't say that I have a plot, only a part of the plot is going to be developed. The other part I'm not touching. It is remaining as a free area without any construction being done. Can you exclude that from the project? You can't, because it's very clear. Now, the common area also mean the common basements, terraces, parks, play areas, open parking areas, and common storage spaces. It also includes the premises for the lodging of persons employed for the management of the property, including accommodation for watch and ward staffs or for the lodging of community service personnel. Installations of central services such as electricity, gas, water, sanitation, air conditioning, and incinerating system for water conservation and renewable energy. Then water tanks, sumps, motors, fans, compressors, ducts, and all apparatus connected with the installations for common use. Now, all community and commercial facilities as provided in the real estate project. All other portion of project necessary for convenient for its maintenance, safety, etc. and common use. So a wide definition is given to common areas. So you can't exclude certain areas just because nothing is done. That concept of development, we should take note of one aspect here. That is the development of the land as mentioned in the building rules. Kerala Panchayat building rules as well as the municipality building rules speak of development of land. What do you mean by development? When you are purchasing a land vast area and converting it into plots, whether you are going to construct a house or a flat or a project there, or you are simply going to divide the area into plots and selling it, that will also come under development. Development with its grammatical variations and coherent expressions means carrying out the development of movable property, engineering or other operations in, on, over or under. In, on, over or under. You have to just the words used here very specifically understood. In, on, over, under. The land or the making of any material change in any immovable property or land or includes redevelopment. So this is the very wide definition for the term development given under the Act. Now planning area is yet another important definition. None of the other definitions are not unimportant. I don't say that they are all unimportant, but because of paucity of time I am just referring to only to important things. Planning area means planning area or a development area or local planning area or a regional development area by whatever name called, or any other area specified as such by the appropriate government or any competent authority, and includes any area designated by the appropriate government or the competent authority to be a planning area for future planned development under the law relating to town and country planning for the time being in force and as revised from time to time. Here, we have to take into account the Town and Country Planning Act of the state, Kerala Town and Country Planning Act 2016. This is an area where there is an interplay of so many enactments. We have the municipal building rules, panchayat building rules being applicable, the certificates issued under those rules. Now, the Town and Country Planning Act, then the general provisions of the Transfer of Property Act, even to an extent specific relief act also when it comes to the adjudication of disputes. Who is a promoter? Promoter means a person who constructs or causes to be constructed an independent building or a building consisting of apartments or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to other persons and includes his assignees. Or 2. A person who develops land into a project, whether or not the person also constructs structures on any of the plots for the purpose of selling to other persons all or some of the plots in the said project, whether with or without structures thereon. Now, we don't have such organizations in Kerala as such, apart from few. Those developmental authorities are also included. That is, any development authority or any other public body in respect of allottees of buildings or apartments as the case may be, constructed by such authority or body on lands owned by them or placed at their disposal by the government. Plots owned by such authority or body or placed at their disposal by the government for the purpose of selling all or some of the apartments or plots. It also includes any other person who hacks himself as a builder, colonizer, contractor, developer, estate developer, or by whatever, I'm sorry, or by any other name, or claims to be acting as the holder of a power of attorney from the owner of the land. He is also included as a promoter on which the building or apartment is constructed or plot is developed for sale. Prospectus means any document described or issued as a prospectus or any notice, circular, or other document offering for sale of any real estate project or inviting any person to make advances or deposits for such purposes. What is a real estate project? Real estate project means the development of a building or a building consisting of apartments or converting an existing building or a part thereof into apartments or the development of land into plots or apartments, as the case may be, for the purpose of selling all or some of the said apartments or plots or building, as the case may be, and includes the common areas, the development works, all improvements and structures thereon, and all easement rights and appurtenance belong there. It also includes easements. Easements also would become part of real estate projects. That is answered by this definition. So we need not have any confusion. Another omnibus definition, that is words and expressions used herein, but not defined in this act and defined in any law for the time being in force, or in the municipal laws, or such other relevant laws of the appropriate government shall have the same meanings respectively assigned to them in those laws. We have seen enactments where words and expressions used herein but not defined will have the same meanings in Contract Act, Transfer Property Act, Civil Relief Act. Likewise, there will be an incorporation by reference. Now here it is a different. It is a very omnibus, not defined in this act and defined in any law for the time being in force, or in the municipal laws, or such other relevant laws of the appropriate government. So it includes everything. Shall have the same meanings respectively assigned to them in those laws. Because the legislature was very conscious that there are sort terms, because this is a law applies to the whole of the nation. So every state will have its own building rules, regulations, etc. Many terms could be used interchangeably. So as to take in all those things into account, this definition has been very comprehensively worded. We are all interested in filing claims. How to file claims, we will come to that. Now, before that, the obligations of the promoter that is mentioned in section 15, 16, the transfer of title, we come to section 18. Now, before I will also refer to section 11. What are the functions and duties of the promoter? That is very comprehensively mentioned in section 11. What are the obligations of the promoter regarding veracity of advertisement or prospectus? Very important section this is. It says, where any person makes an advance or a deposit on the basis of the information contained in the notice, advertisement or prospectus, or on the basis of any model apartment. Suppose you are shown a model apartment. This will be like that. If in such cases also, plot or building as the case may be, and sustains any loss or damages by reason of any incorrect, false statement included therein, he shall be compensated by the promoter in the manner as provided under this. So whenever a person goes to a model project, this is the model house, this is the model apartment, this is the model plot, it contains so and so, so and so and so. Your plot will be also having the same things. If such a representation you are acting upon that and you suffer damage, section 12 takes care of such a situation. When can the promoter take an advance from the persons? That is answered in section 13. A promoter shall not accept a sum more than 10% of the cost of the apartment, plot, or building as the case may be as an advance payment or an application fee from a person without first entering into a written agreement for sale with such person and register the said agreement for sale under any law for the time being in force. Now, this agreement has a form mentioned in the rules. The agreement for sale referred to in subsection 1 shall be in such form as may be prescribed and shall specify the particulars of development of the project, including the construction of building, apartments, along with specifications and internal development works and external development works, the dates and the manner by which payments towards the cost of apartment, plot, or building, as the case may be, are to be made by the allottees, and the date on which possession of the apartment, plot, or building is to be handed over, the rates of interest payable by the promoter to the allottee, and the allottee to the promoter in the case of default, and such other particulars as may be prescribed. So all those things are taken by this particular reference to agreement for sale being in a very particular form. Now, the promoter is also obligated to strictly adhere to sanction plans and project specifications in section 14. Now, often it happens while a project is being conceived and being developed, the promoter may go into red, or he may become financially unsound. So many things are happening in these times. Now, in such cases, somebody else might come and say, "You give the project to me. I will, from that point, take it forward." Now, what are the obligations of the promoter in this case? Now, Section 15 answers that. It says the promoter shall not transfer or assign his majority rights and liabilities in respect of a real estate project to a third party without obtaining prior written consent from two-third allottees except the promoter and without the prior written approval of the authority, provided that such transfer or assignment shall not affect the allotment or sale of apartments, plots, or buildings, as the case may be, in the real estate project made by the erstwhile promoter. There is a transparency aspect here. Suppose a project goes to red. The person who initially started the project is not able to complete it. And under section 15, he intends to transfer. So that there is a examination of the entire aspects by the authority after getting the written consent of the two-thirds allottees, and the authority will ensure that there is no, that is what we expect from the authority also. So there is a statutory supervision by the authority in such cases provided under section 15. There is a provision for taking insurance of the project, that is under section 16. The promoter shall obtain all such insurances as may be notified by the appropriate government, including but not limited to the insurance in respect of the title of the land and building as a part of the real estate project and construction of the real estate project. That is also specified in section 16, which is also a new provision. Transfer of title, that is very elaborately dealt in section 17, which obligates the promoter to execute a registered conveyance deed in favor of the allottee along with the undivided proportionate title in the common areas, as is usually done now. That is given a statutory recognition by under section 17. What happens if the promoter is not able to keep his deadlines? Where is the, how he should, in such cases, how can he be asked to compensate? If the promoter fails to complete or is unable to give possession of an apartment, plot, or building in accordance with the terms of the agreement for sale, or as the case may be, duly completed by the date specified therein, or due to discontinuance of his business as a developer on account of suspension or revocation of the registration under this act, or for any other reason, he shall be liable on demand to the allottees in the case where the allottee wishes to withdraw from the project without prejudice to any other remedy available to return the amount received by him in respect of that apartment, plot, building, as the case may be, with interest at such rate as may be prescribed on his behalf, including compensation in the manner as provided under this act. So he has to return the amount which he was given by you plus the compensation. It has a proviso provided that where an allottee does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay till the handing over of the possession at such rate as may be prescribed. As far as the allottee is concerned, who does not want to withdraw, he is given this right to get interest. Now, subsection 2 also says the promoter shall compensate the allottees in case of any loss caused to him due to defective title of land on which the project is being developed or has been developed in the manner provided under this act, and the claim for compensation under this subsection shall not be barred by limitation provided by under any law of the time being in force. This claim cannot be time barred. That is very clearly mentioned here. I will read it once again. And the claim for compensation under this subsection shall not be barred by limitation provided under any law for the time being in force. Just like we have to take section 10 of the Trust Act, where a trust property can be followed in the hands of any other persons without any period of time being prescribed. So this is akin to that. Therefore, it is a special period of limitation provided in and with reference to section 29(2) of the Limitation Act. A special uh, limitation. Actually, there is no limitation provided. It says declares that that right cannot be barred. So it is a very important aspect as far as this legislation is concerned. Now, the rights and duties of allottees, they are very elaborately dealt with in Chapter 4, Section 19. First is, the allottee shall be entitled to obtain the information relating to sanction plans, layout plans, along with the specifications approved by the competent authority, and such other information as provided in this Act, or the rules and regulations made thereunder, or the agreement for sale signed with the promoter. The allottee shall be entitled to know stage-wise time schedule of completion of the project, including the provisions for water, sanitation, electricity, and other amenities and services as agreed to between the promoter and the allottee in accordance with the terms and conditions of the agreement for sale. The allottee shall be entitled to claim the possession of the apartment, plot, or building as the case may be, and the association of allottees shall be entitled to claim possession of the common areas as per the declaration given by the promoter under subclause C of clause subsection 2 of clause section 4. Very elaborately, other rights are also mentioned under this section where every aspect, insofar as a allottee is concerned, have been addressed comprehensively. Now, under section 20, the real estate regulatory authority has been formed. That is under section 20. It consists of a chairperson and not less than 2 whole-time members. The qualifications, terms, salary, etc., with which we are not much concerned, you can skip that. Filing of complaints with the authority or the adjudicating officer. That is under section 31. Any aggrieved person may file a complaint with the authority or the adjudicating officer as the case may be for any violation or contravention of the provisions of this act or the rules and regulations made thereunder against any promoter, allottee, or real estate agent as the case may be. Section 31 says any aggrieved person. It does not say any allottee. So there is a difference between aggrieved person and allottee. Who is an aggrieved person is not defined expressly in this act. But any person aggrieved, we can find a definition of the word person. Person includes an individual, a Hindu undivided family, a company, a firm under the Indian Partnership Act or Limited Liability Partnership Act, a competent authority, an association of persons, or a body of individuals, whether incorporated or not, any such other entity as the appropriate government may notification specify this behalf. So this is a definition, very comprehensive definition of the word person. Then the explanation to section 31 also says, for the purpose of this subsection, person shall include the association of allottees or any voluntary consumer association registered under any law for the time being in force. The form, manner, and fee of the complaint is prescribed under the rules. Now, what are the functions of the authority? We have a real estate authority in Kerala. What are the functions mentioned in section 32? Among few of them, protection of the interests of the allottees, promoter, and real estate agents. All persons involved, all stakeholders. Now, creation of a single window system for ensuring time-bound project approvals and clearances for timely completion of the project. Now, this is one area where many promoters or builders face difficulties because one authority may give you permission, the other authority may not. There could be delays. But he might have entered into an agreement with an outer time limit with the persons from whom he has taken money. So his grievance should also be addressed. That one of the functions of the authority is to create a single window system for facilitating time-bound approvals. So this is one area where the authority has to apply its mind and comprehensively come out with a system where a promoter can file a single application, and then all the related approvals, sanctions, licenses, etc. will be issued to it. Just like we have the Single Window Clearance Act 1999, we have a single window system where the panchayat or the municipality concerned will also be brought into that. The district collector will be the chairman. He will go through. That is how it is being done. The same way, as far as the promoter is concerned, his rights facilitating an easy working for him to complete the project and hand it over in time. This provision is enacted. Now, the authority is having power to call for information, conduct investigations, etc. Just like a civil court that is mentioned in section 35. Now, the power to issue interim directions, when where during an inquiry, the authority is satisfied that an act in contravention of this act or the rules and regulations made thereunder has been committed and continues to be committed, or that such act is about to be committed, the authority may, by order, restrain any promoter, allottee, or real estate agent from carrying on such act until the conclusion of inquiry or until further orders, without giving notice to such party where the authority deems it necessary. Now, this is something beyond Order 39 Rule 1, because injunctions, temporary injunctions, are governed usually by Order 39, and attachment is under Order 38. Now, if you want to get relief under those particular provisions, you will have to plead and prove existence of prima facie case, balance of convenience, etc., etc. Now, here, nothing of that sort is required. You just have to show that the promoter is going to violate or is violating or is continuing this violation of this act or the rules made thereunder. Straight away, the authority will not ask you, how are you, have you got a prima facie case? What is the balance of convenience? Where is the irreparable injury? No questions regarding that need to be asked here. Straight away, the power is granted. Now, the authority is also empowered to issue directions. Dehorse this. That is under section 37. The authority may, for the purpose of discharging its functions under the provisions of this Act, or rules or regulations made thereunder, issue such directions from time to time to the promoters or allottees or real estate agents, as the case may be, as it may consider necessary, and such directions shall be binding on all concerned. Now, the powers of authority have been further mentioned in section 38. Apart from this, the authority shall have powers to impose penalty, impose interest, in regard to any contravention of obligations cast upon the promoters, the allottees, and real estate agents under this Act or the rules or regulations. The authority shall be guided by principles of natural justice and subject to the other provisions of this Act and rules made thereunder. The authority shall have powers to regulate its own procedure. Where an issue is raised relating to agreement, action, omission, practice, or procedure that has an appreciable prevention, restriction, or distortion of competition in connection with the development of a real estate project, or has the effect of market power of monopoly situation being abused, the authority may suo motu make reference to Competition Commission of India, some kind of cartels and pools being developed by the builders for regulating the price, etc. If it comes to the notice of the authority, now this provision is a very powerful tool. Of course, we don't know how far it will be exercised, but this is a powerful tool whereby such practices we call unfair trade practices or monopolistic trade practices, which were under defined in the earlier laws, all those now stands codified under the Competition Act 2002. Now, by this provision, this authority coming to know about such practices being by the promoters in different areas, it can straight away refer this issue to the Competition Commission. Now, the rectification of orders, just like any other provision, it is there. We have a Central Advisory Council under this Act. Now, thereafter, we come to the Real Estate Appellate Tribunal that is constituted under Section 43. Now, as far as the Appellate Tribunal is concerned, it will consist of one judicial member, one administrative member, and one technical member. Now, 43.5 says any person referred to earlier, any person aggrieved by any direction or decision or order made by the authority or by an adjudicating officer under this Act may prefer an appeal to the appellate tribunal having jurisdiction of the matter. Now, it has a proviso, just like the taxation regulations, provided that where a promoter files an appeal with the appellate tribunal, it shall not be entertained without the promoter first having deposited with the appellate tribunal at least 30% of the penalty or such higher percentage as may be determined by the tribunal, or the total amount to be paid to the allottee, including interest and compensation imposed on him, if any, or with both as the case may be, before the said appeal is heard. That is the very important provision, because it applies as we are viewing this legislation not only from the point of view of the allottees. We will have to view this legislation from the promoter's view angle also. Now, from the act, we can see that there is a right to legal representation under section 56. The applicant or the appellant may either appear in person or authorize one or more chartered accountants or company secretaries or cost accountants or legal practitioners or any of its officers to present his or its case before the appellate tribunal or the regulatory authority or the adjudicatory officer as the case may be. As far as appellate tribunal is concerned, there is other rule also. I will come to that. Section 57 says, every order made by the appellate tribunal under this act shall be executable by the appellate tribunal as a decree of civil court, and for this purpose the appellate tribunal shall have all the powers of the civil court. Now, notwithstanding anything contained in subsection 1, appellate tribunal may transmit any order made by it to a civil court having local jurisdiction, and such civil court shall execute the order as if it were a decree made by the court. That power is also very specifically mentioned as far as the appellate tribunal is concerned. There is another rule which makes the orders passed by the adjudicating officer on the tribunal also as a giving it the status of a decree. We'll come to that. Now, from this order passed by the tribunal, there is a further appeal to the High Court. That is appeal to the High Court. Many of you might have seen that. That is now numbered as MSA. Miscellaneous second appeal. Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the High Court within a period of 60 days from the date of communication of the decision or order of the appellate tribunal to him. Here we have a problem. Any one or more grounds specified in section 100 of the CPC. Substantial questions of law. Only on a substantial question of law, an appeal can be entertained by the High Court, even though it is called an appeal. Even though it is mentioned in our High Court as a miscellaneous second appeal, but Act does not say that it is a second appeal. It only says that it can be entertained only on one or more of the grounds mentioned in section 100. So we will have to fathom both the orders, find out what is the substantial question of law, then we will have to frame it like that. Now, it also takes care of a situation where there could be some kind of a consensus between the parties before the first authority, adjudicating officer, as well as tribunal. Now, 58(2) takes care of such a situation. No appeal shall lie against any decision or order made by the appellate tribunal with the consent of the parties. So that is also taken care of. Now we have the chapter 8, which provides for offences, penalties, and adjudication. Here, even though appellate tribunal comes earlier, there is one important section which we have to take note of. That is the adjudicating officer. Adjudicating officer's powers are mentioned in section 71. That is, we have earlier seen that there are certain sections in this act which provides for granting compensation. So section 71 says, for the purpose of adjudging compensation under sections 12, 14, 18 and section 19, the authority shall appoint in consultation with the appropriate government one or more judicial officer as deemed necessary who is or has been a district judge to be an adjudicating officer for holding an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard. So this is where the adjudicating officer is concerned. He takes care of all these aspects under sections 12, 14, 18 and 19. Section 12, we'll just have a glance on that. I read section 12 to you. There is obligations of the promoter regarding the veracity of the advertisement. If he mentions something false, you have to compensate it. That is section 12. 14 is the promoter has to follow strictly the sanction plans, project specifications, etc. If he violates that is also subject matter for adjudication under section 14. That is 71. Now under 18, return of amount and compensation. That aspect is covered under section 18. It is under the jurisdiction of the adjudicating officer. Now, what are the factors which the adjudicating officer has to take into account? That is mentioned in 72. While adjudging the quantum of compensation or interest as the case may be, under section 71, the adjudicating officer shall have due regard to the following factors. They are the amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of default. 2. The amount of loss caused as a result of default. The repetitive nature of the default and such other factors which the adjudicating officer considers necessary to the case in the furtherance of justice. So these are factors which should be taken by the adjudicating officer under the Act. Now we come to, as in any other enactments like this, there is a bar of jurisdiction of the civil court, as usual in all these enactments, because you have a three-tier structure under this Act, where the rights of promotees, allottees, etc., and persons aggrieved are given opportunity to go there and ventilate their grievances. So, therefore, in such a situation, civil court should not be burdened with. That is taken care of in section 79. No civil court shall have jurisdiction with respect to the matters covered under this Act. We have to remember, whenever there is a bar of civil court jurisdiction, it confines only to those matters which the Act provides and not matters outside that. If you are able to bring your matter outside the Act, you can very well go to civil court. That is a different issue. Now I already took you to section 88 and 89. That is, this Act shall be in addition to and not in derogation of an Act to have overriding effect, etc. Now we have the Kerala rules, which provides for how an application should be made. What all are the matters that should accompany an application? Then how a registration application can be given. All these are mentioned in the Kerala rules, that is Kerala Real Estate Regulation and Development Rules 2018. They were brought into force on 14/6/2018. As per Rule 3, many aspects are mentioned. I need not read it further for you. Just taking you to that. Agreement for sale shall be in form in Annexure A. We have an agreement form prescribed under the rules. So any sale agreement for sales has to be in tandem with that. Now the authority is having a website. What are the details to be furnished in the website is very elaborately given in section Rule 17. Because any intending purchaser can access the website of the authority, which gives a comprehensive information about so many aspects regarding the projects already registered, projects that have been deregistered, against whom actions have been taken, who are all the promoters who have been put under scanner. All those details are available in the website of the authority. Now, rate of interest is one aspect where people will be like to know what is the rate of interest that is payable. Now, Rule 18 of the rules clearly deals with that. The annual rate of interest payable by the promoter to the allottee, or by the allottee to the promoter in case of his default, as the case may be, shall be the State Bank of India's benchmark prime lending rate plus 2%, and shall be computed as simple interest, no quarterly risk. Now, the manner of filing complaint with the authority and the manner of holding inquiry is given in Rule 36. There is a form by which you can give a complaint. That is M. That contains details regarding we have just like we fill up certain forms, and now the grounds for is like that. Now, Rule 27 is an important rule, which I have to read it for you. That is manner of implementation of order, direction, or decisions of the adjudicating officer, the authority, or the appellate tribunal. That is mentioned in Rule 27. As far as appellate tribunal is concerned, I already took you to the other section mentioned in the Act. Now, this was not there, it seems, in the Act. So that is covered by this rule. For the purpose of subsection 2 of section 40, every order passed by the adjudicating officer, authority, or the appellate tribunal, as the case may be, under the Act, or the rules and regulations made thereunder, shall be enforced by the adjudicating officer, authority, or the appellate tribunal in the same manner as if it were a decree or order made by the principal civil court in a suit pending therein, and it shall be lawful for the adjudicating officer, regulatory authority, or the appellate tribunal, as the case may be, in the event of its inability to execute the order, send such order to the principal civil court to execute such order either within the local limits of whose jurisdiction the real estate project is located, or in the principal civil court within the local limits of whose jurisdiction the person against whom the order is being issued actually and voluntarily resides or carries on business or personally works for gain. So this is a very clear provision by which the authority, the orders of the authority and the adjudicating officer can be executed either by themselves being the deemed decrees or they are empowered to send it to the courts concerned also. So these are the broad aspects as far as the Rera Act and rules are concerned. Now, the authority has come out with some regulations also for your information. In 2020, certain regulations have been brought in by the authority. Of course, in tandem with what is stated before regarding some procedure, appointment of the commissioner, etc. General regulations. There is a reference to the CPC there. Code means Code of Civil Procedure for the only for the those limited purpose. Certain forms have been mentioned with which we are not much concerned. But as far as overall working of the act is concerned, it is now seen that many people are started approaching the authority. If you go through the website of the authority, many people have used the jurisdiction of the authority for many purposes under these acts. So people are in Kerala at least, and the next Maharashtra is another state where this is working in a very commendable fashion. We will get the interplay of so many other regulations, laws, etc. as far as act is concerned. So therefore, it is one area where it's not, I don't say that it's very easy. You will have to go through so many enactments also before you draft a complaint under this act, even though the regulations, sorry, the rights, etc., have been declared. But there are certain areas where you will have to rely on the other enactments also. So this is a very important area where now, yeah, as far as the authority is concerned, I will share my experience with the authority. The people in the authority does not like lawyers. They said, you can come, person concerned can come to us and we will help them. But when we observe what is happening in the authority, it is far from what they say because they will impose their decision on these people and as if you want, you take it, otherwise, leave it. This is how, as far as I have observed, I am just sharing my experience. So it is a, and right to legal representation is specifically mentioned in the act. In one of the cases where it was brought to the notice, in fact, it was not taken with the respect required. But we will have to put our feet very firmly. As lawyers, we have every right, and that right is specifically granted to you under this act. Of course, along with the lawyer, chartered accountant, cost accountant, company secretary can also appear. That's a different issue. We have to ensure that complaints are properly, because we find so many complaints lacks very basic details, and because of this, there is some kind of help desk there for the registration, for filing complaints, etc. As I'm not referring to any individual here, but problem is their skewed understanding of this legislation will land the person in trouble. So unless a proper legal advisor aids that person, he will not be able to use the forms, use the rights under this act, and add the reliefs, etc. Of course, we have to have some basic knowledge regarding the building rules and what you call the terms used in the, as far as the building constructions are concerned, carpet area, floor area, all those things. A basic working understanding alone is sufficient. We will have to have a very proactive role as far as this legislation is concerned. And I urge all of you to find time to at least devote some time daily, because it's a big legislation having rules, etc. But you have the website of the authority where the forms are there. So many add-ons are there in those websites. Therefore, we can use it and we can have some kind of a table where if you want to file a complaint, what are the things you have to do, you can chart it out. So therefore, this is an area where these kind of aspects have to be really properly highlighted. So therefore, I'm just concluding my part. Of course, I don't know how far it was monotonous to you, but still, Any suggestions or doubts regarding the working of this act, I will be able to answer as far as I know.